Hello friends, in the series on the income tax cases, today we will discuss an issue on the registration of section 12AA. The limited issue in the present case is that if the assessee has applied for registration under section 12AA and during the pendency of the registration of the assessee under section 12AA, if any assessment proceedings of the assessee are pending for the earlier years and if the assessee is granted the registration under section 12AA, so whether the assessee will get the benefit of section 12AA for all those years for which the assessment proceedings are pending during the pendency of the registration under section 12AA. This issue has been taken by Honorable ITAT Pune bench in the case of Indian Medical Association versus Additional Joint Commissioner of Income Tax Appeals. This matter has been reported in 113 ITR Tribunal short note 60 and the date of the judgment is 26th June 2024. The facts of the case are like this. In the present case, the assessee has been granted a certificate of registration by the Charity Commissioner. The assessee applied for section 12AA registration on 15th July 2016 and the assessee was granted registration on 20th October 2016. Since the date of the registration was falling in the previous year 16-17, so at the face, the registration under section 12AA was applicable from the assessment year 17-18. When this registration was granted to the assessee on 20th October 2016, then on 2nd January 2018, the order under section 143 subsection 1 for the assessment year 16-17, that is the assessment year which was preceding the assessment year from which the registration under section 12AA was applicable, was passed and the CPC denied the benefit of section 11 claimed by the assessee for the assessment year 16-17. The assessee filed the appeal before the CIT appeal and the CIT appeal also denied the benefit of registration under section 12AA for the assessment year 16-17 for which the proceedings were pending during the pendency of the registration under section 12AA, or in other words, when the order under section 143 subsection 1 was passed, at that time the assessee was having the registration under section 12AA. The CIT appeal denied the exemption under section 11 on the ground that the section 12AA is prospective in nature and the benefit will not be given to the assessee retrospectively. When the assessee carried this matter to the tribunal quoted the proviso to section 12A subsection 2 and said that that proviso says that the benefit of section 12AA registration should be given to the assessee for all the assessment proceedings which are pending during the pendency of the registration under section 12AA. Since in the present case, when the registration was given, that is on 20th October 2016, after that the order under section 143 subsection 1 was passed, or in other words, when the order under section 143 subsection 1 was passed, at that time the assessee was holding the valid registration under section 12AA, so the assessee is entitled to get the benefit of section 12AA read with section 11 for the assessment year 16-17 also. It is also a settled law that if the assessee has filed the return of income and even if the assessment is not going on under section 143 subsection 3 or in any other section, then it will be deemed as the proceedings are pending. So the assessee will get the benefit of section 12A subsection 2. The tribunal also said that in the present case, the CPC has not doubted the charitable activities of the assessee, and the tribunal also said that even if the registration benefit is not to be given to the assessee, then in any case, the whole receipts of the assessee cannot be taken as income of the assessee. The tribunal said that proviso to section 12A subsection 2 was introduced just to remove the genuine hardship of the assessee, and the benefit of that proviso should be given to the assessee for the assessment year 16-17. At the end of this video, once again I am repeating the name of the case. The name of the case is Indian Medical Association versus Additional Joint Commissioner of Income Tax Appeals, and this case has been reported in 113 ITR Tribunal short note 60, and the matter has been decided by Honorable Pune ITAT, and the date of the judgment is 26th June 2024. Thank you, friends.